Dear friends, I'm Homi Bhabha. I direct the Mahindra Humanities Center, and I want to welcome you all to an event very, very close to my heart and extraordinarily important for us all. But before I give my brief introduction, and today it will be brief, we have a very full program, let me remind you, as I have been reminded several times by my friends and colleagues, there is a book sale and a book signing outside. Don't forget about that. Go there. They think that I'm slightly losing it. That's why they keep telling me, don't forget, don't forget. So I haven't forgotten. But it's a real pleasure to see you all here today. I never tire of saying that without our very committed and engaged audiences, we could do nothing. But because you are here and you follow us, to various events, Anne Blair talking about Erasmus's amanuenses had as enthusiastic a group as you are today. So there's a range of things we do, and we love it, and we love you to be with us. Thank you so much. It is especially fitting that we're hosting Carol and Jordan Steiker to celebrate and discuss their new book, Courting Death, the Supreme Court and Capital Punishment, in the final year of our Mellon University-wide seminar on violence and nonviolence. It was Carol who inspired and guided our conference on mass incarceration 3 years ago, a conference that previewed and, in a sense, launched the Mellon seminar. Carol, thank you for all you do and for your loyalty to our ideas and your contribution and advice. You really feed our commitment, and I can't thank you enough. The whole criminal justice issue, or the criminal injustice issue, is very central to the Humanities Center. We feel it brings together a number of issues of race, inequality, psychic suffering, physical suffering, pain, a whole range of issues for us. And it has become a central headline item for us, and we try to do something on a regular basis. And next year we have a plan to unfold a series called The Street and the Prison. In fact, on another aspect, dealing with another aspect of this, we had Anna DeVere Smith give our Rita Hauser lecture, and she talked very much about radical hospitality and the inhospitality of both schools and the education system and cultural institutions. In the midst of this extraordinary election season, the presence of the strikers this evening is a matter of urgency. The language of violence, death, and incarceration has been insistently and indiscriminately thrown around by Mr. Trump. Mexican migrants are portrayed as murderers and rapists. Muslim refugees are accused of terrorism. Pro-choice professionals have been described as fetus rippers, and Mrs. Clinton should undoubtedly be locked up without due process. Mr. Trump's phantasmatic free associations may be more the stuff of the psychoanalyst's couch than free speech exercised from the stump. But there is more at stake for this country than a crazed devil's apprentice revving up millions of his followers with an apocalyptic vision of a massive crime wave provoked by migrants and minorities. Mr. Trump's allegations may be incoherent and trumped up, but no amount of fact-checking after the event can reduce or mitigate the damage done by a public discourse that manipulates the uncontrollable affects of anxiety and insecurity in the name of law and order. This discourse creates what I call a carceral imaginary that inculcates a demand for punishment fired by fear and loathing that feeds off racial prejudice and social disadvantage. The grave implications of courting death are nowhere more harrowingly and humanely explored than in Carroll and Jordan Steiker's landmark work. The carceral imaginary, as they brilliantly demonstrate, inflicts a deep and lasting wound on the very body of the law itself. In reviewing Courting Death for the Harvard magazine, Lincoln Kaplan deftly summarizes the grave distortions that wreak havoc with legal process and procedure. And I quote him, "Many states have imposed the death penalty in ways that discriminate by race and geography. Countless juries have been confused. Thousands of trial courts have made serious legal mistakes. Thousands of lawyers, unprepared for the demanding nature of the work, have given slipshod counsel to people charged with capital crimes." And all that comes from one paragraph. Our panelists will turn to these issues and many others this evening. For my part, and on behalf of the Mahindra Center, I want to acknowledge the significant contribution made by members of the Harvard Law School to the humanities at Harvard. They are amongst our closest partners. Members of the law school community have collaborated with us on many occasions through the years, and they have been vigilant in keeping us honest and just. We realize with them that interpretation at its best, literary interpretation, ethical, aesthetic, is a kind of jurisprudence. Described as the most influential legal scholars in the death penalty community, the Steikers were commissioned by the American Law Institute in 2009 to write a report on capital punishment. That report has had a profound effect on views about death penalty in recent years, and their book will no doubt resonate even more powerfully and decisively if, as the New York Times claimed in an editorial on Monday, that the death penalty is nearing its end. Much of the credit should go to Carroll and Jordan. Carroll Steiker is the Henry J. Friendly Professor of Law at Harvard. Jordan Steiker is the Judge Robert M. Parker Chair in Law and Director of the Capital Punishment Center at the University of Texas School of Law. After they speak, our panelists will take the stage. Lawrence Bobo will go first. He is the W.E.B. Du Bois Professor of the Social Sciences at Harvard, and he's currently working on the Race, Crime, and Public Opinion Project. Charles Fried is the Beneficial Professor of Law at Harvard. Gregory Fried is Professor of Philosophy at Suffolk University. They are the co-authors of Because It's Wrong, Torture, Privacy, and Presidential Power in an Age of Terror. Elaine Scarry is the Walter M. Cabot Professor of Aesthetics and the General Theory of Value at Harvard. Her most recent book is Thermonuclear Monarchy, Choosing Between Democracy and Doom. I welcome you all to this important evening of deep discussion of a problem that affects all of us, because, in a way, the question of prison, the question of incarceration, is pain in its most extreme form. And to deal with it, to actually deal with it, is to deal with one of the most important issues in our understanding of human dignity. Thank you very much for being here. Let me ask Carroll and Jordan to come up. Can I please remind you to turn off your cell phones? When you make this demand, people always somehow assume that their cell phones have been turned off. But this is something you've got to do. Take the thing out, press the button, and then put it back in again.
Thank you so much, Homi, for that lovely introduction and for inviting us to speak here as part of the Mellon seminars, Mellon Foundation events on violence and nonviolence. We're especially thrilled to have this wide-ranging and distinguished panel responding to our work, which even includes another pair from that exclusive club of relatives who write together.
In-laws.
In-laws. I love it. That one I haven't heard before. Our book, as the title suggests, addresses the last half-century in the life of the American death penalty, the period in which the United States Supreme Court has engaged the practice of capital punishment through an ambitious project of constitutional regulation. Now, many people think and say and write that what is most distinctive about the American death penalty is that we are alone among Western nations in retaining the death penalty. And this is certainly true. The United States is actually one of the top 5 executing nations in the world, along with China, Pakistan, Iran, and Saudi Arabia, not our usual club. But we think that what is truly unique about the American death penalty is that ours is the only nation in the world that has neither simply abolished the death penalty, like England or France, or simply retained it as another tool in the criminal justice system, like Singapore or Yemen. Rather, we have attempted to rationalize and reform the practice of capital punishment through top-down judicial regulation under the Constitution. So our book chronicles what Justice Harry Blackmun called the Supreme Court's experiment with capital punishment. And we're particularly pleased that the Mahindra Center, with its incredibly broad range of scholarly engagement, has set up this program. Because while Jordan and I are both lawyers and legal scholars, our account breaches traditional disciplinary boundaries and explores themes that have dimensions that are historical, sociological, and rhetorical, as well as legal. So I'll begin by considering some historical and sociological resonances, and then Jordan will pick up with legal and rhetorical ones. Now today, anyone who reads the paper, really any American, knows that if you have an important question about capital punishment, eventually the United States Supreme Court is going to answer it. Can juveniles get the death penalty? Can you get the death penalty for crimes less than murder? What does a death penalty trial have to look like? What kind of evidence must be or may not be introduced? Just actually this past month, in its very first sitting, the U.S. Supreme Court heard the case of a Texas man who was sentenced to death after an so-called expert witness testified that he was more likely to be a danger in the future because he was black. Based on the court's questioning, I'm betting against Texas on this one. But it wasn't always so that the U.S. Supreme Court was the place where you went to get answers about capital punishment in America. In fact, for most of American history, the Supreme Court had really virtually nothing to say about the practice of capital punishment in our country. The practice was thought to be largely one of state and local prerogative, invoked by local officials to address distinctively local concerns. So compare these two images. Yeah, come on. There we go. Compare these two images. On the left, you see a woman named Mary Dyer, who was executed actually here in Boston in 1660 for the crime of heresy. She had been banished. She was a Quaker, and she had been witnessing and preaching here in Massachusetts Bay Colony, and she was banished upon pain of death. She returned and was tried, sentenced, and executed actually on Boston Common. If you go downtown, you can see a statue to her in front of the State House, which bears the warning inscription, Witness for Religious Freedom. It's a warning about the dangers of religious intolerance. But in her own time, her execution was a warning of a different kind. The Puritans of Massachusetts Bay Colony used their capital punishment statutes to enforce their, deeply religious ideas about the kind of community they wanted to be. On the right, however, you see actually a slave who had been convicted of an attempted slave rebellion being burned at the stake in the South. So in the South had capital punishment too. In fact, every one of the original colonies had capital punishment at the time of the founding. And in the South, the death penalty was used much more to police the enslaved population and protect the slave economy. And when slaves particularly engaged in violent crimes against their owners or attempted to revolt, they were not only punished with capital punishment, but also more gruesome forms of it. So torturous punishments like breaking on the wheel and burning at the stake were reserved for slaves who violated these rules. So, we don't execute, obviously, Quakers or slaves anymore today, but two features of these outmoded practices remained true for centuries in the United States, which was that capital punishment was a state and local affair, and that it was the prerogative of political officials, state legislators, governors, attorneys generals, prosecutors. It wasn't a question for courts, and it certainly wasn't a question for federal courts, for the federal government. So when the United States Supreme Court entered into this fray in earnest in the 1960s and early 1970s, this was a substantial break from the long sweep of American history. Now you might be asking, what was it that brought the United States Supreme Court at this late date into the project of regulating capital punishment in America? And one of the things that brought the United States Supreme Court in was that the historical connection between the death penalty and race in America. So let me just go through the next slide. So it isn't, here is the traditional form of punishment, not burning at the stake, but hanging on the gallows. And it wasn't as if death penalty practices never changed between, the founding era and when the United States Supreme Court came in. Certainly there was a lot of change, most notably along the lines of modes of execution. So you can see some of the modes of execution that we've cycled through in the United States. But it wasn't until the Supreme Court's intervention that the issue of race really began to be joined as kind of the central issue in the death penalty. And the checkerboard of practices around the death penalty that existed in the United States, you can see here. In the United States, because of local prerogatives, you had, it's not exactly a checkerboard because you can see these strong regional divisions. The South was and remains today the most active death penalty jurisdiction in the United States, and no states in the Deep South have ever been among any states that have repealed the practice of capital punishment. And even today, the connection between executions today and the death penalty today is most connected to places where there were lynchings in earlier parts of American history. So in the 19th century, prior to the Civil War, as I just mentioned, the South had statutes that were distinctive for slaves and had special death penalties for slaves. And that included not just slave rebellion, but, for example, rape was a crime that only black men, either slaved or not enslaved, could get. White men could not get the death penalty for rape in the South until after the Civil War. After the Civil War, when you could no longer have race-based distinctions under the Constitution, the Southern states continued to have the death penalty for rape, but applied it only to freed black men. You might have thought that after there was no need to protect the slave economy through the use of capital punishment, that capital punishment might die out in the South. But in the postbellum period, there was great fear in the South of violence by the freed black population. And this was the period of lynchings, which were, if you want to think of it as a kind of unofficial capital punishment, so extreme that at the height of the lynching period, which was in the 1890s, there were more lynchings than there were legal executions. As a result, in the South, the Southern states, especially progressive lawmakers in the South, very much supported retaining the death penalty because they thought only by retaining the death penalty could they constrain and, in fact, hopefully eliminate this practice of lynching, which was a black eye on their states and on the power of governments to control the mob, to control mob violence. And so you began to have what my colleague Mike Klarman has written about what he calls and what many called at the time legal lynchings, the practice of extremely fast trials at which the judge and the local officials would assure the angry crowd who was calling for blood that there would be a conviction and a hanging of black defendants accused, even on very flimsy evidence, of serious crimes against whites. And it was against this backdrop that the Supreme Court eventually entered into the constitutional fray. And the most important case was this one. It's called Powell versus Alabama. The so-called Scottsboro Boys were 9 black teenagers who were accused of raping 2 white women, and they were all, riding a freight car, kind of hoboing in Alabama through the South. The 2 women accused the 9 black men on extremely flimsy evidence of raping them. 8 of the 9 were convicted and sentenced to death with virtually no legal representation. The Supreme Court issued in this case in 1932 its first holding ever in which it made a special rule for capital cases that didn't apply to ordinary criminal cases. It said you couldn't be convicted and sentenced to death without a lawyer because the men had virtually no legal representation in that case. It wasn't until more than 30 years later in Gideon versus Wainwright in 1963 that the Supreme Court extended that right to all criminal defendants in serious capital cases. So Scottsboro and these legal lynchings, this incredibly fast and unreliable trial in Alabama, is what led the Supreme Court to issue its first ruling. In fact, the last of the Scottsboro Boys, all of them were eventually officially pardoned by the state of Alabama, the last 3 most recently in 2013, 3 years ago. But Scottsboro and this example in Alabama was kind of the culmination of this racial history of capital punishment, which surprisingly has been somewhat lost to public understanding. How many high school debates and college debates are there about capital punishment in America? And sure, we talk about racial disparities, but even in this moment of Black Lives Matter and the understanding of police discretion and discrimination, the incredibly deep, entwined, and sordid history of capital punishment and slavery, lynching, and race in the United States has become somewhat submerged from view. And fast forward from the 1930s, not that much happened in the Supreme Court. That was kind of a shot across the bow in 1932 when Powell versus Alabama was decided. But in 1963, not only was Gideon versus Wainwright decided, but a very liberal justice named Arthur Goldberg, who had a very liberal law clerk named Alan Dershowitz, both of them were very much opposed to the death penalty. And Justice Arthur Goldberg thought it was a good time for the Supreme Court to get into the business of regulating the death penalty. And interestingly enough, this case, Rudolph versus Alabama, was an echo of Scottsboro. Rudolph was a black man accused of raping a white woman in Alabama and sentenced to death. And Justice Goldberg told his young law clerk to write a memo that would get the 4 requisite votes to grant the Supreme Court's review of this case. And Alan Dershowitz wrote this very long memo. It's in the Library of Congress. You can read it, detailing many of his concerns about the death penalty for rape. This was not a murder case. This was only a rape case, as the Scottsboro Boys case was. And Justice Goldberg got 2 of the necessary 3 other votes. He got William Brennan, he got William O. Douglas, but 3 votes, not 4. So it was a dissent from the court's failure to grant review. Interestingly, Chief Justice Earl Warren, who had penned and led the 9-0 majority in Brown versus Board of Education 9 years previously, did not vote to grant review. He saw the court as engaged in a challenging racial justice project in terms of enforcing, eventually, Brown versus Board of Education, and he did not want the sympathetic faces of school children to be mingled with what he thought were less sympathetic faces, such as accused rapists and murderers. So not only did he not join Justice Goldberg / Alan Dershowitz's dissent from denial of cert, he asked Justice Goldberg, and Justice Goldberg acceded to this request, to remove any mention of race from his dissent from denial of cert, which Justice Goldberg did. Justice Goldberg's dissent said the court should grant review to consider whether the death penalty for the crime of rape as opposed to murder is just per se excessive. He and Alan Dershowitz schemed to leave in a footnote that had sources in it that talked about the racial problem. And they figured if people read that footnote and went and read the sources, they would see that that was part of the argument, but they didn't make the explicit argument. Nonetheless, the code was cracked. The day that this case was decided, Jack Greenberg, who took over from Thurgood Marshall as head of the NAACP Legal Defense and Education Fund, the group that had litigated Brown versus Board of Education in the 50s, and some lawyers from his office were having lunch in Central Park. And they said, you know what? The court may be ready to address this issue, and we are going to adopt this issue, capital punishment, as our new project. This was our racial justice project. This was the NAACP, LDF, that had made school desegregation their project in the 40s and 50s, and now they decided to make capital punishment their project in the 60s. And they were very ambitious about it. They launched a nationwide campaign. They were not really a national organization yet at the time, but they partnered with the ACLU, which had affiliates in 48 states, and they sent around what they somewhat facetiously called last rites kits, in which local lawyers could raise challenges to the death penalty, and they brought the American death penalty to a screeching halt. There was one execution in 1965, down from more than 100 just a decade or two previously, 2 executions in 1966, and then 0 executions in 1967, 68, 69, 70, and 71. It's the longest period the United States has ever gone without executions as a result of the NAACP's strategy. And eventually, they had a landmark success. In 1972, the Supreme Court struck down capital punishment as it then was practiced in the United States in the landmark case of Furman versus Georgia, 5-4. Interestingly, per Justice Warren's admonition, not really on the grounds of race. Once again, this was submerged. The court talked a lot about arbitrariness, freakish and wanton application, about the death penalty being cruel and unusual, the way being struck by lightning was cruel and unusual. Once again, I think many people read through the code and saw this as about race, although the court did not address it. And this, at this point, was launched the Supreme Court's major intervention, and I'm going to let Jordan come up and talk about the Supreme Court's continuing intervention and its consequences. So let me use that.
So when Furman was decided in 1972, many people thought, and you can imagine given the size of the headline in the New York Times, that the American death penalty had run its course in the United States. In retrospect, it's pretty clear that many of the justices on the Supreme Court thought that this was the end of the death penalty. The death penalty had already been a withering practice, declining in death sentences and executions before the Justice Goldberg dissent from denial and before the decision in Furman. But surprisingly, there was a quick, vociferous, and decisive reaction by American states to revitalize the death penalty. 35 states quickly passed new capital statutes to deal with the discrete problems that the court had identified. And 4 years later, the Supreme Court was finally confronted with the question that they had not answered in Furman, whether in all circumstances the death penalty is cruel and unusual punishment prohibited by the Constitution, by the Eighth Amendment. And in the face of the tremendous backlash to the Furman decision, the Supreme Court upheld a number of those statutes and rejected the idea that the death penalty itself violates the Constitution. And so from that period on, from 1976, 40 years ago, to today, we have occupied this unusual position in which the death penalty itself has been declared constitutional, but the court has endeavored to regulate the practice through a variety of complicated and intricate constitutional doctrines. And when Carol and I first started writing about the death penalty in the mid-1990s, we were struck by the extent to which the capital doctrines seemed to both legitimate and stabilize the death penalty. On the one hand, we observed that the constitutional regulation of the death penalty, although it seemed very intricate and very complicated, actually was quite minimal. It actually required very little of states to construct capital statutes and provide for constitutional capital trials. But nonetheless, the court had not communicated particularly clearly the minimal demands that the constitutional doctrine required. States had reacted slowly or inadequately to the demands that were communicated. And as a result, many capital sentences were invalidated. There was a tremendous amount of dislocation in the capital system. But there was this perception that the court was managing the American death penalty. And we describe this phenomena as a sort of legitimation because many of the actors in the criminal justice system, and many actors outside of the criminal justice system, thought that this process was being intensively regulated. And so prosecutors and jurors, executive officials, the public at large felt increasingly comfortable with the American death penalty, even though on close inspection, the doctrines had done very little to cure the many problems of the death penalty. And so part of our book is an effort to sort of document the minimalness of the constitutional regulation, but the way in which it paradoxically strengthened and revitalized the American death penalty. You would think that constitutional regulation would have narrowed and constrained and limited the death penalty, but the American death penalty grew substantially in the years following the constitutional intervention by the court, and many people believe that the court had gone too far in its intrusiveness, and death sentences and executions began to rise dramatically. So that's the picture of the rise of executions, which peaks in around 1998. This is, and below is the death sentencing. You can see that we have sort of the height of American death sentences actually just before that 1998 when there were over 300 death sentences a year. So we have this phenomena of regulation, both legitimating and entrenching the American death penalty, making people feel more comfortable with its administration than they otherwise should have. And in fact, there's a good reason to believe that if the Supreme Court hadn't intervened at all in the 1960s and 70s, that the death penalty was on a trajectory of weakening and dissipating, and that we might not have seen anything like the climb in death sentences and executions than we subsequently saw. But as time went on, we saw another phenomenon with constitutional regulation, another phenomenon which, like the first phenomena of legitimation and entrenchment, was unanticipated, unexpected, and in a little bit paradoxical, which is even though the constitutional regulation was minimal, did not require much of states, the fact of regulation required states and federal courts to restructure themselves to deal with the constitutional regulation. And on the ground, capital practices started to change, not again because the Constitution required that practices to change, but because there were new institutions and institutional actors involved in the death penalty. Before the 1980s, there were no such thing as death penalty lawyers in the United States. If you go back to the 1970s, 1960s, there were some experts at LDF on the death penalty, but no one embarked on a career of being a death penalty lawyer. But once there was constitutional regulation, the states and the federal government started paying for offices for lawyers who would work on these capital cases, usually in post-conviction, for dealing with cases after they'd gone through trial. So state post-conviction lawyers, federal habeas lawyers appeared on the scene, and those lawyers began to vigorously challenge the things that happened at trial, the quality of representation, the way in which juries were selected. And so again, even though the court didn't demand a change in the level of practice, the fact of regulation triggered the creation of these new institutional actors. And those institutional actors managed to destabilize the death penalty. And it destabilized it in a number of ways. One way in which the American death penalty was destabilized was the amount of cost that would just be generated by having these institutions. Another way in which the practice was destabilized was that it started to, the comfort that people had with capital sentences because of the court's involvement began to unwind as we learned more about the actual inaccuracy of capital verdicts and the experience of wrongful convictions. So beginning really in the late 1990s, we start to see a tremendous decline in death sentences, a tremendous decline in executions, and I think much of this is attributable to constitutional regulation, but not really attributable to the strength of constitutional norms so much as the way in which the practice transforms itself because of the court's extensive apparatus of constitutional doctrine. I want to talk a little bit about the way in which today it appears that there's the possibility of constitutional abolition of the death penalty. That's not an actual accurate photograph of the court, and no names attached to the, well, actually you can sort of make them out a little bit. Again, the court's regulation still today remains quite minimal, but a number of the things that have happened because of constitutional regulation have made constitutional abolition possible. A number of states that had the death penalty have abandoned the death penalty. We had 38 states with the death penalty a little bit more than a decade ago. Today, we're down to 30 states with constitutional death penalty statutes on the books. As I showed before, the number of death sentences, I think this bottom chart, even though it's small, I think it's the most significant chart about the American death penalty, which is death sentences have declined about 75 to 80% nationwide. It doesn't come up to the current year. Oh yeah, or maybe it does. 2015, 49 death sentences nationwide. The number in Texas, new death sentences in 2015 was 2. This is compared to about 40, 45 death sentences a year in the late 1990s. And this has resulted from the increased costs, the fear of inaccuracy, and other things. And it's just if there's any leading indicator of the future of the American death penalty, it's the remarkable decline in death sentencing, as well as executions. And the decline in executions is in part because of the elaborate institutional structures that are now in place for inmates who are on death row. So there's been tremendous lethal injection litigation. The Supreme Court has never endorsed any of that litigation, but it means that in every state, lawyers are going to be arguing on behalf of death sentenced inmates about the adequacy of the drugs and the protections and their lethal injection protocols. And so we have not quite as dramatic, but still a very dramatic decline in executions from a height of close to 100 to last year, I believe there were 28 executions nationwide. And this year, we're certainly going to have fewer than 25 executions nationwide. So there's an interesting story about the ways in which constitutional regulation affect practices on the ground without actually commanding a high level of protection. But I want to turn to the rhetorical aspect of our book, in which we focus on the ways in which the discourse surrounding the death penalty has changed as a result of constitutional intervention. In the 1960s, the primary argument against the death penalty, and really almost you could say since the Enlightenment, the most prominent argument against the death penalty is that it violates human dignity, that it deprives individuals of life, it creates an inappropriate relationship between the government and individuals, that it grants a power that states shouldn't exercise, especially in the wake of the experience of the Holocaust and Stalinist Soviet Union. And that was the primary driving argument that motivated anti-gallows societies throughout American history and opponents to the death penalty in the 1960s. Those arguments found very little traction in the Supreme Court. They were marginalized in the 1972 decision of Furman versus Georgia. They essentially disappear after the Supreme Court upholds the death penalty in 1976. And the focus thereafter is on the administration of the death penalty. How accurate is it? How arbitrary is it? Whether or not it's whether there are sufficient procedural safeguards to prevent all kinds of capriciousness. And the lawyers who are sort of the vanguard of the anti-death penalty movement in the United States shift their strategy. And the strategy from 1976 on is about the administration of the death penalty. At the same time, in the 1960s and 70s, supporters of the death penalty supported it largely on sort of more deontological, foundational moral arguments about, supported the death penalty on more pragmatic arguments, sort of hard-headed arguments about deterrence, about cost, and about incapacitation. So the debate in the 1960s was framed as sort of these soft-hearted moralists who opposed the death penalty for deep moral reasons, and hard-headed supporters of the death penalty who supported the death penalty, supporters of the death penalty who believed that it was necessary just as a practical part of criminal justice. But that's entirely flipped. Over the last 4 decades, the regulation of the death penalty has shifted the sort of pragmatic ground on the death penalty. It's made the cost argument, which used to be a pro-death penalty argument, now an anti-death penalty argument. The focal point on the sort of pragmatic aspects of the death penalty is illustrated in numerous ways, but I think the most telling way is the way in which opponents of the death penalty have even shifted their strategy from asking for abolition of the death penalty to repeal of the death penalty. They want to avoid the sort of moralist language about the death penalty being somehow immoral and that there's this imperative to get rid of the death penalty, to an argument about how it's important to be smart on crime rather than to abolish the death penalty because of its immorality. At the same time, I think, supporters of the death penalty have retreated to a different position. Supporters of the death penalty no longer argue about deterrence. They no longer argue about incapacitation, in part because of the adoption of life without possibility of parole. They no longer argue about the death penalty as sort of a pragmatic tool in the criminal toolbox. Instead, supporters of the death penalty have moved to retribution, have moved to the argument that there are some crimes that are so evil and some individuals who are so evil that the only proportionate response can be their extermination. And actually, one way of illustrating this shift in strategy, I was invited to participate in a debate about the death penalty. And 20 or 30 years ago, the question would have been, should we have the death penalty as a punishment for murder? And it would be sort of a general debate about the death penalty. I was invited by a conservative group, the Federalist Society, on the law school campus, and they said the question that we will debate is whether or not there are at least some offenders for whom the death penalty is appropriate. The argument now is really, is there a retributive core for some offenders that deserve the death penalty, rather than a pragmatic assessment of the entire capital system, whether the capital system as a whole is working fairly and efficiently and as a pragmatic tool in criminal justice. And our book tries to illustrate that the way in which the court and the court's intervention transformed the death penalty debate and ended up, I think, contributing to the sort of the way in which the sides have shifted from instrumental versus sort of deontological argument about the death penalty, can be illustrated in other areas in which the court has regulated. And I'll leave you with this thought. Think about the issue of gay rights and same-sex marriage. Before the court got involved in this issue, the popular debate, the political debate, was about whether or not gay relationships were immoral. And that was the focal point of the debate. And in the early Supreme Court case, that was the way in which the court ultimately upheld the criminalization of private consensual behavior. But once the court got further involved and basically said sort of purely moral objection to gay relationships was not a constitutionally permissible basis for opposing or for criminalizing conduct, the question then turned to the more instrumental questions about whether or not same-sex marriage would have good or bad pragmatic consequences for the United States. And so the last few years of public debate, I think in part because of constitutional regulation, has focused not on is homosexuality a sin, which was the focal point of political discourse for decades, but instead the question of whether or not same-sex marriage would discourage heterosexuals from marrying, whether it would be bad for children of same-sex couples, whether it would be bad for children of heterosexual couples to have same-sex marriage legalized. And these sort of, by shifting the ground of the debate, I think the court, in some sense, shifted the way in which the public discourse about the issue takes place. And so while it's very conventional wisdom to say that the Supreme Court reacted to the emerging support for gay rights to recognize a constitutional right to same-sex marriage, I think it's also important to note that the way in which the court framed the issue, the way in which the court framed the debate, ultimately actually ended up in sort of facilitating that shift in popular view about gay rights and same-sex marriage. Because once the arguments were framed in pragmatic terms, the sort of absurd arguments that were made against same-sex marriage, which were transparently absurd, they weren't logical in themselves, they certainly didn't have any empirical foundation, ultimately made it that much easier for the court's final intervention. So that's our presentation.
Well, thank you so much, Homi, and the Mahindra Center for inviting me to be a part of this very provocative session. Carol and Jordan Steiker offer us a carefully researched, beautifully written, and deeply provocative assessment of the role of the U.S. Supreme Court has and may yet come to play in the fate of capital punishment in the American criminal justice system. They suggest that the death penalty will not last much longer in the United States, judged against larger global trends, the increasing constraint and regulation that the court has imposed on the death penalty, especially post-1976, and the number of justices who now renounce it even though they once may have imposed death sentences. Courting death suggests that the writing is, so to speak, on the wall. In all likelihood, the death penalty is on the way out. In that judgment, one senses a kind of guarded faith and optimism in the court and its capacity to do good. I find myself, in the main, wanting to applaud the erudition and honesty of this book. It is scrupulously careful in reviewing the historical and legal background of the imposition and evolution of the death penalty. In particular, it is quite unequivocal in its recounting of the racist and discriminatory patterning of the implementation and application of the death penalty, really right up until the present moment. Likewise, I'm impressed by the remarkable balance and attention to countervailing forces and trends that Steiker and Steiker take into account in fashioning this argument right up to the very final pages of the book. Yet, it is a concern with some of these countervailing tendencies and forces that will preoccupy me for the few minutes that I have here this evening. I enter this first and foremost not as a lawyer, not as a legal scholar, unlike virtually everyone else up here, but at the place where prejudice, politics, and public opinion meet in the American experience. That background has led me to take as a starting point an observation recently offered by Michael Klarman, who said, quote, "According to conventional wisdom, the U.S. Supreme Court heroically defends unpopular religious and racial minority groups from majoritarian oppression. As Justice Hugo stated in a landmark 1940 decision, the court protects the rights of the helpless, weak, or non-conforming victims of prejudice. This view, however, is deeply flawed. A quick review of American history reveals that the court, more often than not, has been a regressive force on racial issues." It's kind of riffing off of that I want to work with. I do not mean to suggest that Steiker and Steiker are in any way Pollyanna in their treatment of the Supreme Court on race issues, especially regarding capital punishment. Indeed, Chapter 3 is a very powerful indictment of the astonishing silence, indeed near open duplicity, of the court on matters of racism and discrimination as forces affecting the use of the death penalty, including, kind of tragically, Thurgood Marshall, whose own opinions in this arena make virtually no mention of race and discrimination. Rather, I wish to flesh out a bit more of the likely social and political context that helps account for this duplicity, and I will do so by burdening you with a little bit of data from previous research of my own, which is to say, and we'll see if that works, 3 national surveys and a set of focus groups I did in early 2000, 2001, 2002. We don't need to focus on the details here. But what I do want to draw your attention to really are 3 failed experiments. We don't often report on failed experiments, but these were actually substantively important failed experiments. And they're experiments embedded in otherwise nationally representative sample surveys. So you get the power of randomized control linked to a fully representative population sample. The first of these experiments I call the death penalty demography experiment, where following certain political rhetoric, we just try to point out to folks there are a heck of a disproportionate number of black folks on the death penalty. Does that affect, on death row, does that affect whether or not you support capital punishment? So a randomly selected third of respondents are asked the standard survey question that people have been asking more or less since 1935. A randomly selected third are told, by the way, blacks are only 12% of the U.S. population, but over 40% of those who are on death row, now do you still support this thing? And to try to pull things in another direction, another randomly selected third are brought attention to the fact that blacks commit a disproportionate share of homicides, all right, to try to see if it pulls it in another direction. The long and short of the story is nothing changes. And this is experimental randomized controls. These are statistically equivalent national samples in each of those 3 versions. It didn't do a thing to get the average American to think about death row demography. This led us to a second experiment then. We said, okay, let's focus on the one arena in which we know racial bias is still pretty clear cut in the application of the death penalty, and that is, woe be to you if you kill a white person in America. Your odds of ending up on death row are awfully high. So we did a murder victim race ballot experiment. Again, standard question. Half the sample is told at present someone who murders a white person is much more likely to be sentenced to death than someone who murders a black person. Standard question. Nothing changes simply by pointing out this particular form of racial bias. Here we did a little bit more elaborate analysis. I'll draw attention quickly to 3 things because this is the kind of regression analysis that troubled, I think it was Justice Powell. But Here it is, some regression analysis. The experiment itself has no effect. If we control for a lot of other interesting factors like how much schooling a person has, political liberal or conservative, whether they think the system's biased against blacks, the single biggest effect in this model, and it's what I'm going to keep coming back to, is a measure of racial prejudice. It's huge, and it matters for white respondents, but not African-American respondents. I'll come back to this. But the point is the taste for punitiveness is strongly tied to racial prejudice, even in the modern moment. Let's do the third build, where we really thought we were going to produce an effect. That is that people are putting out the fact that they're innocent people ending up on death row. Our risk of actually executing someone who should not have been at risk of losing their life at the hand of the state is tragically high. So we tried to do a version of that, and to make it concrete for people, we asked them, let's assume a candidate for governor in your state announces, I'm going to oppose the death penalty because the risk of executing innocent people is simply too high. Does that make you more likely, less likely to vote for this person, or not affect your choice? Even just point blank, you ought to be concerned that a full third of the population nationwide said it made me less likely to do so. That's the first indication that there's something going on here. We pointed out at the time we did this survey, which was 2002, I think, that at that point in time, 79 people who had been on death row were found to be innocent and had been released. That is, they're really clear-cut cases of exonerations of folks on death row. Then what happens? And this worried us more because nothing happened. There was no movement once you hit people over the head with the fact of exonerations being part of the story. Again, no experimental effect, control for the kitchen sink. That racial prejudice measure is still the single biggest thing happening in this equation. Punitiveness and prejudice tied in the U.S. for some of the historical reasons that Carol and Jordan have already reviewed. Now, we might puzzle to ourselves, why is that the case? And this is the logic of the larger question I want to pose for them. Focus group discussions we held as part of this project are suggestive in explaining this. Two illustrations may help here. Participants in separate white and black focus groups were almost uniform in strong contrast to my expectations in their express willingness to see teenagers as young as 14 and 15 be tried as adults if they were accused of committing murder. After the moderator of the white focus group had gone around the entire room of 12 subjects and heard everyone voice support for trying juvenile killers as adults, one of the white male participants said, quote, "Does everybody realize that we think it's all right to try a child younger for murder than it is to try them for shoplifting? It just struck me that that is what we have decided." No one in the group seriously re-examined their opinions in the wake of this pointed observation. Furthermore, in the black focus group, one of the participants, whose own son had been arrested for what she regarded as a trivial possession of marijuana charge, and who bemoaned the stultifying presence of police officers and metal detectors in her son's school, nonetheless took a very harsh position with regard to the death penalty, even though some other members of the black group argued with her. In the course of the discussion, she said, the moderator said, should we be using the death penalty more aggressively? Despite an immediate answer of no from one of the black male participants, this woman whose son had been arrested said, yes, we should. People have been sitting on death row for years. It's time to electrocute them, make room for the new ones. I understand that, well, who are we to judge? But hey, you do the crime, you do the time. Forget the time. You killed that person, and if it's that severe, they should go. And I would pull the switch. Just to give you a sense of the energy and the type of logic that all this other information and complexity and even concern and personal experience with racial bias didn't necessarily derail that way of thinking about it. Now, subsequent to our research, the number of exonerations has marched upward and nearly doubled in the intervening years from 2002, going from 79 to 156. So there's still people being let off death row despite the effort to regulate and do this more smartly. The good news here is that public opinion, the taste for something like the death penalty, isn't fixed. It's changed enormously since 1936. It was on its way down for much of the 60s, moved way back up so that by, I think this is 96, it got to about 80% of the population supporting the death penalty. But it's been steadily trending downward ever since to actually slightly less than a majority now claim to endorse it. As Jordan has already shown us, the number of executions is way down. But two things remain true. Blacks are disproportionately represented, though not as heavily so as in the past, so some of this constitutional management, procedural rule following, has begun to mitigate the extremity of racial bias. But the bias in terms of white victims continues to be quite substantial here. And where am I here? So the current composition of death row inmates may be close to where I will end here. I guess the question I kind of want to pose in a larger fashion is perhaps the court was right to avoid race. That building a slow case for managing and then greatly narrowing the application of the death penalty largely on procedural claims rather than racial justice grounds as it did, has resulted in a steady narrowing of the scope of the death penalty. Most brutal forms have been ruled out. You have to have counsel. You have to have competent counsel. We don't execute the mentally retarded anymore. We don't execute teenagers or put them on death row anymore. There have been this steady series of inroads, and that kind of procedural logic led the way for much of that. But what I worry about still is that the failure to address race, the failure to lay the historical case, the failure to create the rhetoric opens the door to political mobilization on the basis of that racial prejudice, which is still a big mountain out there and is still part of the taste for this in the American mass public. Quick case in point, the 3 strikes and you're outlaw in California, which was a case where the state legislature had already enacted a 3 strikes and you're outlaw, partly in response to the murder of Kimber Reynolds, I believe. But then Polly Klaas is kidnapped and killed by another multiple offender, and Kimber's father becomes just a zealot activist in behalf of 3 strikes and you're out legislation. He and an activist group draft what became the most extreme legislation. It goes straight to the California Initiative ballot. It's not even reviewed by the California Legislative Office. Goes straight to the ballot from an activist group and passes. And a 5-4 Supreme Court ruling holds it up, and you get the case of where the 3rd strike doesn't even need to be a violent felony. It doesn't even need to be a serious felony. You'd be a felon who stole a slice of pizza. But now you're sentenced to life in prison because it's the third strike. And that type of mobilization is what worries me in a context where we might someday see the court from on high say, no, we're going to stop here. The good news is that public opinion has moved in this enormously salutary direction as elites have made decisions that have narrowed the scope and use of the death penalty. But that spark of potential for mobilization, in the absence of building the logic, the rhetoric, the legal principles for resisting it that are at least partly tied explicitly to racial justice concerns, worry me. And I would want to push you to say a bit more about whether the court could have done a lot more on that front that might well have had some salutary benefits down the road. But fundamentally, thank you very much.
So on November 8th, while all of us are at the polls racking our brains about which candidate to vote for, people in California will be doing the same, but they'll also be having to vote about 2 referendum matters. One is Proposition 62, which asks if they want to abolish the death penalty or repeal the death penalty. And if they do, then the maximum sentence in California will be life imprisonment without parole. But they also have to vote on another proposition, which is Proposition 66, which asks whether they think that the time to execution should be shortened. And in that case, they would be voting to limit the number of appeals that people on death row could have before they are put to death. Now, if you're like me, when you hear those 2 propositions, they sound wildly contradictory. And in fact, when you read the balloting website for California, it points out that in the event that both propositions win out, that both propositions win with a yes vote, the one with the highest number of yeses will be the winner. It sounds incoherent, but that's only if you haven't yet read Carol and Jordan's book, which makes it seem much more coherent. Because as they point out, going along with this incredible, almost catastrophic problem of the death penalty in so many of our states is the very grave problem of the number of years that people sit on death row, often in solitary confinement, which is considered by some standards a form of torture. They point out, for example, that the time to execution in 1988 was, I think, 6 years to execution, and in 2012 the average was 14 years, and they give figures for many, many more years than that in some states. In some states, as they point out, it's the third leading cause of death. People on death row will die of other causes before they will be executed. So right now we're, as you've been hearing, on the path to the elimination of the death penalty, in part as the result, as they argue, of the well-intended but failed attempt to regulate the death penalty. And they show 4 major forms of regulation. One is trying to narrow the number of murder cases that will seem to demand death penalty by asking for the aggravating circumstances to be looked at. A second is to take into consideration mitigating circumstances of the perpetrator. A third is the issue of proportionality, whether it really is commensurate with the crime. For example, was it a rape case, which is now normally taken not to be proportional to the death penalty, and then also asking for what they call heightened reliability, since death is distinguishable from all other kinds of penalty and therefore demands certain kinds of special inquiry. The elimination of the death penalty, in turn, as they show, will likely lead to improvements in the criminal justice system in other respects. It's very likely, they think, that it will lead to the life sentence without parole, which is something that obviously contains no hope for people or any incentive to try and do better or to behave generously while in prison. It will also certainly lead to the elimination of solitary confinement, since it's death penalty that most often leads to people being kept in solitary confinement, of which there are a high number. And they say at the end of the book that it may well lead to reduced sentences in what are smaller sentences, simply because the whole punishment system has to have some proportionality. And if you have the ceiling set at death penalty, then the next levels down are also going to be very high. Whereas if you don't have death penalty, then you have some incentive for having the steps below that be correspondingly small. And in many, many countries, sentences bear no resemblance to the kind of sentences we have in this country. So on the eve of the death penalty disappearing, California's Proposition 62 and 66 remind us of what this book really teaches us throughout, and that is that the criminal justice system, and this is probably by no means their major point. I thought that I was going to be the last speaker, so I was putting aside some of the other major points, and the major points are all about this issue of the death penalty itself. But in addition to that, what we see throughout the book, and the reason why it stands up not only as a brilliant book on the first reading, but a book that really invites you to read it 2 times, which I haven't yet been able to do, or 3 times or 4 times or 5 times, is that it really has kind of heartache questions in it about the nature of democracy. As they point out, a lot of the tremendous weaknesses that have come about in this country in association with the death penalty, as well as some of the strengths, come from the feature of localness. And you saw on the map that Jordan put up that there's a tremendous divide among the states, among those states that have the death penalty and those that don't. It's roughly a north-south divide, with 30 states still having the death penalty. And then within that, there's tremendous variation, because they show that there's a set of those 30 that literally have execution, and then another subset where it seems to be a kind of symbolic penalty that actually isn't acted on. And they invite us to wonder whether this is what they call simulated gallows, that is the 21st century equivalent of what in the colonial times actually was a literal sort of ceremonial act of pretending to put someone on the gallows. And of course, there are many, many other variations in addition. But the one of the issues they raise is the reason why we've been so slow as a country to eliminate the death penalty. By comparison, for example, Germany eliminated this death penalty in 1948 in its constitution. Sweden had already done so in the 1920s. England eliminated it in 1965. France in 1981. Spain in 1978. Ireland in 1973, Poland in 1998. So those are very, very different timetables. And the reason they give is that in those other countries, the decision about it was a top-down decision. Whereas in the United States, it's in part a top-down decision, as you can hear in the account the rich account we've just been given of the intervention of the Supreme Court, but it's also a criminal justice system that is simply embedded in local ground. And the local ground, of course, varies greatly, and it is, as they say, citing a critic named David Garland, a kind of hyper-democracy. And for those of us who are fans of democracy, it's very painful to see that local ground has this consequence, as often seems to be the case in things that involve racial decisions. Now, I should say that the issue of that local ground and its interaction with the courts at different levels, the state's courts and the national court, is a complicated one, because they also show a very interesting interaction between popular activism and what the courts are doing. So, for example, the case in 1972 that you heard about happens shortly after the high water mark of popular opinion against the death penalty. So that would seem to be very much a kind of crediting of the popular will on this matter. And it's I think that it's also present in the number of times that their book really allows to surface very powerful individual voices who have a tremendous impact. Justice Marshall and Justice Marshall's effect on the two of them. Or you heard about the Alan Dershowitz opinion that he writes. Or we hear about a particular lawyer, Tony Amsterdam, who has tremendous effect. Or we hear about the Ruth Ginsburg, before she was a justice, writing an amicus brief on the issue, on the inappropriateness of using the death penalty for rape. So it's a complex picture of, on the one hand, the jury system seeming to be have a regressive pull, or at least a racially unfair pull on the one hand, and of individual voices and popular actions having a great deal of effect. We know that Justice Marshall himself had concrete experience in the area of defense, and that's part of the reason he became so strong on this issue. And the puzzle for me goes in two directions. On the one hand, from the very beginning of the social contract theory that most influence our own Constitution, that is Hobbes and Locke, the actual work of individual jurors was very much stressed. Hobbes talks about the fact that the whole population should be given statute books the way they're given Bibles, because he says, we're as capable of making good decisions as highly trained jurists are if we only were given the right books to read. And the other kind of background thing that makes me so puzzled by this is the fact that in the other area where our country is in as bad a situation as we are with the death penalty is our own arrangements for nuclear weapons. We have the most powerful nuclear weapons on Earth. And it comes, and in part, the complete silence of the population on this issue comes from the fact that there is no kind of local ground on which it interacts with any of us, and therefore seems like something that can only be addressed through disembodied federal officers. So.
Thank you very much. I do apologize for the slightly prison-like feeling of this panel. We're rather crowded in today. We couldn't work it out better.
Homi Bhabha is my chief here, and he strictly limited me to 5 minutes. And as an experienced Supreme Court advocate, I follow those indications. And I thought that since I only had 5 minutes, the best thing for me to do was to put myself forward, not as an advocate, not as an analyst, but as an exhibit. Until not so long ago, I accepted and defended the death penalty as a rare but sometimes entirely appropriate aspect of our criminal justice. Then my son Gregory and I wrote our book, Because It Is Wrong, examining the morality and the politics of, among other things, torture. And we concluded that torture in all circumstances, even the rather strained hypothetical of the ticking time bomb circumstance, where innocent lives may be immediately at stake, is wrong. Wrong because it dishonors the humanity of the subject, turning him into a howling locus of pain, and then it dishonors all of us. If we claim that that is something we may do to each other. But in course of making this argument, it dawned on us that, of course, it applies even more strongly to the death penalty. Without even the exercise of evading, even without the excuse of warding off an immediate evil. At best, we aim to use the executed person as an example, and in fact, at that time, what we do, instead, we make an example of ourselves as killers. Projected on the cover of the Steikers, of the Harvard magazine advertising the Steikers book, is a modern execution chamber. It might be the prep room of a modern operating theater. It mocks us. Instead of deploying the machinery of modern medicine to do no harm, we do the greatest harm we can. This must stop. Thank you.
I also am confined to 5 minutes, and I'm going to try very hard to stick with that, despite the fact that this book is so inspiring and so interesting and can lead us down so many paths of inquiry. And I really am pivoting off of the talk by Professor Bobo, and specifically his the experiment where you showed that, I'm not sure what you called it, but the killing white people experiment, right? That there is a big impact on the taste for punitiveness based in prejudice, right? And so one thing that I'm interested in your book is the story of racialized punishment in American law that you tell in the earlier chapters of your book and haven't said much about today, but I want to tell a kind of a hypothetical historical story about that in the law and see what you think of it. Because one of the cases that we haven't talked about here is the McCluskey case in 1988. And the McCluskey case was argued on social science data very similar to what you're citing, Professor Bobo, the famous Baldus study that showed that black defendants accused of killing white victims were 22% of them received the death penalty, whereas only 8% of white defendants killing white victims received the death penalty. But the Supreme Court argued that that was not enough grounds to make the death penalty unconstitutional as being equal protection of the laws and so on. They said, and this was Powell writing, McCluskey's claim throws into serious question the principles that underlie our entire criminal justice system. Why? Because the Baldus study indicates a discrepancy that appears to correlate with race. And furthermore, that these apparent discrepancies in sentencing are, according to Powell, an inevitable part of our criminal justice system. Thus, if we accept McCluskey's claim that racial bias has impermissibly tainted the capital sentencing decision, we could soon be faced with similar claims as to other types of penalty, and going further, to other types of discrimination on the basis of minority status, gender, even ugliness, and overthrow basically the entire penal system of the United States, which is based on discretion at all levels. And so if you can show that there's discrimination on the basis of discretion in the legal system, we had basically close all the jails and let everyone free if we're going to let McCluskey free, right? So that was, to me, a very shocking part of that case's decision. And Powell later in life, as you report, regretted his decision in McCluskey, right? So where does this come from? The story you tell early in your book is a story about the use of the death penalty in colonial America and then in the United States of America, where the death penalty is used disproportionately against black people, against people who are enslaved, and for a much broader range of crimes and in a much more barbaric way. And the cases that I want to point out on this issue is the Ed Johnson case of 1906 in Chattanooga, right? And this is at a time where southern states are really trying to clamp down on black voting. And Tennessee went from something in the 100,000s of black voters to like 1,900 black voters within a year or something. And this man, Ed Johnson, was convicted in a ridiculous court proceeding, and Justice Harlan accepted a writ of habeas corpus. And when he did that, a mob took Johnson and lynched him, and the police sheriff shot him 5 times and said, come get your guy now, Justice Harlan, right? And what Harlan's response to that was that the possibility that intrusive federal judicial review of state court trials would lead to mob violence was very real, and it likely played a role in the court's unwillingness to read the 14th Amendment's promise of due process expansively. And you both go on to say that this meant that the federal Bill of Rights might well have been unenforceable, at least in the South. So after the Civil War, the lynch law takes precedence in the South over statutory law and constitutional law. It comes in the back door and effectively becomes the law of the land. And so the question I had thinking about this is, how could that possibly have happened? How could that have happened when in 1804, John Marshall promulgates the idea of judicial review, and that becomes enforced by the Constitution, by the government. However, Marshall is still on the court 25 years later when the court decides in favor of the Cherokee Nation that they can't be abused by the state of Georgia. And President Jackson says, I don't care. And they commit genocide against the Cherokee people. And the court can't do anything about it. And it strikes me that that's the same dynamic that then goes on all the way through in the case of the death penalty, where the lynch law has been the ghost in the machine all the way up through McCluskey. It's still legalized lynching. And why cannot the court face up to that directly and deal with it as a bitter fruit of the American experiment?